Arbitration number, case exercise number 3, simulation number 3. Vega Construction Limited, a contractor, entered into an agreement with HMDA for construction of an elevated expressway between LB Nagar Crossroads and Rajiv Gandhi International Airport, Shamshabad. The project will ease the traffic hassles of the airport commuters and reduce travel time by about 50%. The agreement was entered into by the parties on 12th June 2018. The agreement contains an arbitration clause which provides all disputes shall be resolved by arbitration. The place of arbitration is in Hyderabad. So here we have an arbitration agreement, and Indian law is applicable because the seat of the arbitration is Hyderabad. Next, the details of the project are as follows. Value of the work at 211 crores. So that is the value of the work, value of the contract. Then the work has to be completed within a period of 24 months. That is the time is of essence clause. If the execution of the work is delayed by the conduct of any party, the defaulting party is liable to pay to the other party liquidated damages amounting to a sum of 1% of the total value of the work. This is the upper limit. That is the liquidated damages is the upper limit of damages that can be claimed by either of the parties. That's also mentioned here. The contractor mobilized men, material and equipment in order to complete the work within the stipulated time where the work was in progress. The HMDC revised its letter 21 June 2019, that is the cause of action. First, asked the contractor to stop work due to pandemic. COVID-19 had struck the country. Then, pre-stoppage value of the work. What is the pre-stoppage value of the work? The second week of June 2019, work to the tune of 98.5 lakhs had been completed by the contractor. The contractor was left with no option. There's almost 50% both time as well as work. Almost. Slight difference. The contractor was left with no option but to suspend the work, leaving all the material and equipment idle at the site. HMDA did not intimate the contractor the likely time for restarting the work because even they did not know because central government was controlling it. Even after, but it continued to keep silent even after the notification of the unlock rules by Government of India, which was a further cause of action, which gave rise to a further cause of action, which permitted some construction activity in the COVID-19 outside the COVID-19 hotspots, starting of 20th April 2020. The area governed by the contractor falls outside COVID-19 hotspots. And one more further cause of action is the contractor violated its letter 2nd May 2020 intimated to the HMDA about his intention to carry out another third-party work, but the authorities denied permission to do so because he wanted to utilize the idly lying assets. That's a fun. One more further cause of action is after a period of 2 months of delay from the date of contractor asking for permission to do third-party work, 2 months of delay from receiving the report of the Government of India unlock rules, HMDA gave clearance to the contractor for the execution of the contract and then restart the work. The contractor completed the project by the end of October 2021. That is the relevant date of completion of the contract. The contractor claimed additional damages by way of loss increased for keeping the machinery comprising 10 trucks and 2 cranes idle for a long time. This is a prayer for which no logbook was maintained. This is the proof not available. It's the question of proof not available. Okay, no logbook was maintained by the contractor, but the contractor produced the receipts of charges paid towards the servicing of the vehicles by the garage company on different dates of different vehicles. This is the relevant evidence documents quantifying the loss sustained by him, expenses incurred by him for maintaining the machinery. This is the claim number 1. The contractor raised a dispute claiming liquidated damages under the contract, citing delay on the part of HMDA. The claim number 2 is further claim was made for additional damages for keeping the trucks idle and claimed a sum of 1 crore 24 lakhs from the HMDA. Sole arbitrator has been appointed by the parties and arbitrator to arbitrate the dispute, conduct arbitration and draft the award. This is the exercise number 3. Then for the same people, exercise number 4 is a conciliation. For the above problem, conciliate between the parties and draft a conciliation agreement after a successful conciliation. Successful conciliation is what is given. The draft and memorial are prepared. The guidelines provide for an instruction as Part 1 Arbitral Awards in General, Part 2 is Part 1 General, published by Chartered Institute of Arbitration, London. Part 1 Arbitral Awards in General, Part 2 Awards of Interest, Part 3 Awards of Costs. Part 1 covers the following. Article 1 How to draft and communicate arbitral awards. Article 2 The titles that are most commonly used. Article 3 Conduct of deliberations. Article 4 Form and content of awards. Article 5 Issues arising after a final award has been communicated. Now here the arbitration award memorial, sole arbitrator office BVS in the matter of Vega Construction versus complainant versus HMDA respondent. The parties, first part is the parties. The parties are the complainant Vega Construction, the respondent HMDA. Arbitration. Second para is arbitration. The complaint was filed with the court, Senior Civil Judge, City Civil Court, Commercial Court, Civil Court Complex, Hyderabad, by the complainant against the respondent listed above. The court verified the complaint and complaint together with the annexures to the complaint and satisfied the formal requirement of the contract of the Indian Contract Act, Arbitration and Conciliation Act 1996. In accordance with the rules, the clauses of contract and rules framed under the Arbitration and Conciliation Act 1996, the court appointed me as the sole arbitrator for adjudicating upon the dispute. The parties were notified about the appointment of arbitrator on so-and-so date. The panel of arbitration from which my name was chosen by the court has complied with the statement of acceptance and declaration of impartiality and independence as required by the Act and rules thereunder. The arbitration proceedings commenced on so-and-so date, 2023. In accordance with the rules parts, the respondent was notified by me about the commencement of the arbitration proceedings and the due date for filing their response through their legal representatives. The respondent filed the response to the complaint on so-and-so date within the stipulated time period of number of days granted by the panel vide its notice so-and-so. The language of the arbitral proceedings has been agreed to in English, and the facts and circumstances in person hearing was not considered necessary for deciding the complaint, and consequently, on the basis of the statements and documents submitted on record, the present award is passed. The present award is passed within the period of 60 days from the date of commencement of the arbitration proceedings as per the rules. Now, third part is subject matter of the contract and dispute, and hence arbitration. 1. Contract for the construction of elevated expressway between LB Nagar, X Road to Rajiv Gandhi International Airport, Shamshabad. Second, value of work is 211 crores. 3. The work has to be completed within a period of 24 months from June 2018 to 2020. Time is of essence clause. 4. If the execution of the work is delayed by the conduct of any party, the defaulting party is liable to pay to the other party liquidated damages amounting to a sum of 1% of the total value of the work of 211 crores. In terms of arbitration agreement, 2 crores. 2.11 crores. Terms of arbitration agreement between the parties. The contract was signed and entered into with effect from 12/6/2018 with an arbitration clause which provided that all disputes shall be resolved by the arbitration only. Arbitrator being a chosen or appointed by the judge, City Commercial Court in City Civil Court by Hyderabad, and the place of arbitration or seat of arbitration shall be Hyderabad, and the laws and rules applicable will be those applicable at Hyderabad. Fifth, summary of facts, procedures, and how and what of dispute. The contractor mobilized money, men, and material and machinery in order to complete the work within the stipulated time. While the work was in progress and completed to the tune of 98.5 lakhs, that is by the second week of June 2019. 1 year completed in terms of time, that is 50% time over, and 46.61% of work in value terms has been accomplished. The HMDA vide its letter 21 June 2019 asked the contractor to stop work due to pandemic COVID-19 lockdown ordered by Government of India. 6. Cause of action and source of origin of dispute. The HMDA vide its letter dated 21 June 2019 asked the contractor to stop work due to pandemic COVID-19 lockdown as ordered by the Government of India. The contractor was left with no option but to suspend the work, leaving all the material and equipment lying idle at the site. HMDA did not intimate the contractor the likely time for restarting the work even after the notification of unlock rules by Government of India, which permitted some activity in the non-COVID hotspots starting 20th April 2020. The area of operation of contractor falls outside the COVID hotspots. Seventh point is cause of action number 2. The contractor violated 2520 intimated to HMDA about its intention to carry out another third-party work, but the authorities denied permission to do so, to make use of the idly lying assets. 8th, cause of action number 3. After a period of 2 more months from the date of receiving Government of India report in June 2020, HMDA gave clearance to the contractor and delay of 2 more months for the execution of contract, that is resumption of work on the contract. The contractor completed the project by the end of October 2021 with a total delay of 1 year 4 months, July 2020 to October 2021. 9. Summary of issues and respective positions of the parties. When the contractor claimed liquidated damages as per the contract terms, citing delay on the part of the HMDA in allowing him to resume work on the contract. Is COVID-19 an act of... Second issue is COVID-19 an act of God, and if so, that is force majeure? If so, who should make good the loss and who will formulate the rules for doing so? Third, the contractor claimed additional damages by way of loss of profits, expected profits incurred for keeping the machinery comprising 10 trucks and 2 cranes idle. Third, the contractor did not maintain any logbooks in support of the above claim. He produced receipts of charges paid for the parking, servicing of vehicles by the garage company on different dates for different vehicles. Third, the claim amount for additional damages was 1 crore 24 lakhs. Then fourth item is MORTH circular number COVID-19 roadmap JSH 2020 Government of India, Minister of Road Transport and Highways, Transport Bhavan, New Delhi. Subject: Atmanirbhar Bharat relief for contractors and developers of road sector, dated 18th May 2020. The following measures are hereby notified for providing relief to contractors, developers and concessionaires of road sector from the impact of COVID-19 subsequent to lockdown and other measures taken to prevent spread of COVID. Para C. MORTH letter H-25016 by 01 by 2018, dated 25/3/2020, conveyed that the lockdown period and subsequent prevailing condition of low traffic due to COVID-19 epidemic outbreak may be treated as force majeure of the concession and contract agreement. Para 1, Clause 2, reimbursement of 75% of administrative expenses to be calculated for period 26th March 2020 to 19/4/2020. Para 2-3, reimbursement of up to 50% of administrative expenses to be calculated for the period 24/2020 and later for the slow resumption of normalcy. In SC decisions on the relevant issues. Limitation. Supreme Court suo motu took up the issue of extension of limitation wide order 23/3/2020 2020 SC online SC 343, ordered that the period of limitation in all such proceedings, whether condonable or not, shall stand extended with effect from 15/3/2020 till further orders. Given under power under Article 142, read with Article 141 Constitution of India. To impossibility of performance is covered under Section 56 of Indian Contract Act 1872. Impact on contractual timelines by COVID-19 lockdown as impossibility to function situation. Third, Government of India circular dated 19/2/2020 on force majeure clause regarding manual of procurement of Government of India 2017. New communication issued by Government of India on 18/5/2020 on the same subject and waiver of charges payable by the contractors regarding highways. Fourth, SC Energy Watchdog vs CERC case 2017-14-SEC-80 and Delhi High Court, Halliburton Offshore Services vs Vedanta Limited, OMP 881 by 2020. Fifth, the Government of India notification dated 19/2/2020 says a force majeure means extraordinary event beyond the human control, such as the event described as an act of God, like natural calamity or events like war, strike, riots, crime, and negligence. An FM clause in the contract, force majeure clause in the contract, frees both the parties from contractual liability and obligation when prevented by such event from fulfilling their obligations under the contract, and force majeure clause suspends it for the duration of the force majeure. 6. Full operability of the contract is hindered by orders of the national and state governments, that is, by circumstances beyond the control of petitioner. 7. In Halliburton Offshore plus SC, in the Energy Watchdog decision regarding force majeure, para 56, there is no doubt that COVID-19 is a force majeure event. 8. SC Principles on Force Majeure in Event Watchdog vs. CERC 2017-14-SCC-80. A force majeure would operate as a part of a contract as a contingency under Section 32 of the Indian Contract Act 1872. B. The doctrine of frustration could be invoked by a party as per Section 56 ICA, Indian Contract Act, which would include impracticability or uselessness in keeping in mind the object of the contract. D. If an event or a change of circumstances, promisor finds that it is impossible to do the act which he had promised. 2. Express terms of contract cannot be ignored on equity. C. Risks have to be borne by the parties. 8. Respective parties. 8. Performance is not discharged if it is onerous. H. Alteration of the circumstances is not frustration. I. Doctrine of frustration has to be applied narrowly by the courts. J. A mere rise in cost or expenses does not lead to frustration. H. If alternative performance exists, force majeure will not apply. Then next, terms of contract, knowledge, expectation, assumption, nature of supervening evidence to be considered. Next, if contract has inherent risks, force majeure not to be involved. Next, unless there is a break in identity between the contract as envisioned originally and its performance in the altered circumstances, force majeure not to apply. All above, Delhi High Court is also given in MEP Infra versus South Delhi Municipal Corporation. Mitra Guha Builders Company versus ONGC. SC held employer contributed to delay, no penalty, or liquidated damages disguised as penalty. SC in Karnataka versus Sri Rameshwara Rice Mills. Para 7. Party to agreement cannot be an arbiter in his own cause. Whether delay caused by whom and by whom is to be determined objectively and by a third party only, like arbitrator, and quantum of liquidated damages is calculated as per contract terms. In the case JG Engineers Private Limited versus Union of India 2011-5-SCC-758, para 17. Contract clause does not attract finality to the question as to whether the contractor has failed to complete the work or portion of the work within our agreed time schedule, whether the contractor was prevented by any reason beyond the control or by the acts or omission of the respondents, and who is responsible for the delay. SC in the case of Mitra Guha versus ONGC, if further adjudication under clause is allowed, it will render the agreement meaningless and redundant. Remedy shall lie in the ordinary course of law and not arbitration. Scope of finality is on levy and quantification of liquidated damages. The same is consequential to and distinct from the primary power of adjudication, the issue of the party responsible for such breach, and further, the employer cannot be an arbiter in his own cause. Second, the SC has not considered that even if the claim against the levy of liquidated damages is not referred to arbitration, the contractor may refer other claims, such as escalation on account of delay caused by the employer, to the arbitrator. In such cases, the arbitrator will be required to determine the party responsible for delay in completion of the contract. Next case, Bansal Brothers case, Union of India versus Bansal Brothers, Delhi High Court, 31/1/2022. As per Section 19 of ACA, sole arbitrator can determine the admissibility, relevancy, materiality, and weightage of any evidence. No violation of natural justice and award in accordance with the public policy of India. It was an obligation on the arbitrator to take into account terms of contract and trade usages applicable to the transaction. In accordance with the mandate of Section 28(3) of the Act and for non-compliance of the aforesaid mandate. Under Section 74, can receive as reasonable compensation such liquidated amount, if any, only if it is given genuine. Liquidated damages can be awarded not exceeding the amount so stated in the contract. Liquidated damages or penalty is the upper limit beyond which the court cannot grant reasonable compensation. Reasonable compensation will be fixed as well-known principles that are applicable to the law of contract, which are found in Section 73 of Indian Contract Act. Where it is possible to prove actual damage or loss, such proof is not dispensed with. The section applies to both plaintiff and defendant equally. Delhi High Court in Asban Paints Private Limited versus Union of India, Manu by DE by 0648 by 2001. In case contract was not performed and there was breach thereof by the petitioner, it was for the respondent to prove that the loss suffered because of such breach. It is more res integra that liquidated damages is not a debt and requires adjudication by the court or arbitrator. Arbitral tribunal has the jurisdiction to decide as to which party was responsible for delay. Breach of contract is equal to not maintaining the progress as per clause, that is failing to complete the work as by contract date, and failing to complete the work. Unjust enrichment cannot be countenanced and has to be eschewed. No liquidated damages when no loss suffered. Analysis of the arbitrator's findings as to the facts and application of law to these facts. 1. Timeline of the project with the different events and its interpretation. 2. Start of the project is equal to date of agreement June 2018. 3. Stoppage of work due to pandemic on act of God force majeure event June 2019. Time completed till then 50%, half time allotted. Then work completed till then 46.6%, moderately less. Then permission to start work by lifting restrictions by Government of India in April 2020. Contractor willing to start using his machinery and men on another site or contract. That is opportunity cost. Start date May 2020. Contractor given go ahead to restart the contract by HMDA June 2020. The period lost due to pandemic only June 2019 to April 2020. Period lost due to lack of administrative clearance attributable to the inaction on the part of HMDA May 2020 to June 2020, that is 2 months. 11. Period of opportunity cost for the contractor as he was denied permission to use his assets for another project May 2020 to June 2020, that is 2 months. Then completion of the work October 2021. Then delay in completion of the work overall June 2020 to October 2021, that is 17 months. Delay due to COVID-19 lockdown June 2019 to June 2020 to 1 year, that is 12 months. Force majeure period is 100% affected. Then delay beyond the occasion of the COVID-19 period is 5 months. Then delay occasioned by the lack of administrative clearance is 2 months. Delay that caused the opportunity loss is 3 months. Then period for which HMD is solely responsible for the loss of contractor on account of opportunity loss is 3 months. Period for which force majeure applies is 12 months. Operative part containing award or decision. We award liquidated damages to the extent of 75% of actual cost of parking charges and repair charges of the vehicles as evidenced by the garage receipts for 12 months being the period of delay caused by Government of India, HMDA surplus and COVID-19 pandemic restrictions, subject to the limit of liquidated damages written in the contract. We award additional damage of 100% loss caused by the inaction of HMDA with opportunity cost less calculated at 100% of actual repair and parking charges, and 3. Loss of business and profit calculated at 10% of the contract value or alternative work, that is permission denied. Then we direct each party to bear their own costs. Reasons for decision. The contract is affected by 2 events, force majeure event and inaction or delayed action by HMDA. 2. For force majeure, we follow MOSTH circular. 3. For HMDA delayed action, HMDA is held liable to pay for the loss on account of opportunity cost, loss of profits, expected or possible profits at 10% of the work contract. Then principles of equity, Uberema Fede, Government of India circular, Supreme Court, High Court rulings on various issues. Sign. Then next is simulation number 4, same conciliation agreement based on same Vega Construction versus HMDA. The agreement made this day 8 February so between Vega Construction and HMDA, whereas certain disputes and differences have arisen and subsisting between the aforesaid parties relating to the contract for construction of elevated expressway between LB Nagar X Road to Rajiv Gandhi International Airport. Value of the work 211 crores. Time period 24 months. And whereas the parties agree to submit their disputes for amicable settlement in accordance with the ICADR Conciliation Rules 1996, now the parties hereby agree as follows. 1. The parties agree to resolve the dispute by conciliation in accordance with ICADR Conciliation Rules 1996. 2. Sole arbitrator so-and-so is appointed by ICADR following the ICADR rules. 3. The conciliation shall be administered by the ICADR in accordance with the ICADR conciliation rules. 4. The place of conciliation shall be Hyderabad, ICADR premises. The parties have agreed to the following resolution of disputes listed as below. Dispute number 1. The contract was signed in June 2018 to be completed by June 2020, 24 months. But it was actually completed and handed over by October 2021 with a delay of 1 year, 4 months. Resolution. Both the parties have agreed to the facts as given above. There is no difference of opinion on the dates of scheduled and actual dates of contract completion. Dispute number 2. The cause of a delay on account of two supervening events. First being the COVID-19 lockdown force majeure event lasting from 21/6/2019 to 24/2020, on which date Government of India allowed work to be resumed on non-COVID hotspots. Resolution. Both parties have agreed that force majeure guidelines of Government of India shall apply for the above period of postponement of work 21/6/2019 to 24/2020. The relevant MORTH circular number COVID-19 by roadmap by JSH 2020 by Government of India dated 18/5/2020 is agreed to be the basis for resolution of this dispute for this period. As per the above circular, it is agreed that this period will be treated as res nullius, that is not counted for the contract period, and no penalty will be levied on the contractor for delay during the period during which no work could be carried out, as the contractor was genuinely faced expenses not contributing to the completion of the contract by way of parking and repair charges of these vehicles. An amount equivalent to 75% of the actual expenses towards parking and repair charges of transport vehicle, earth moving equipment will be reimbursed by HMDA to the contractor. Dispute number 3. The Government of India flagged off limited resumption of work in the non-COVID-19 hotspots on 24/2020. But HMDA delayed the onward permission to the contractor till 20th June 2020, 2 months from 24/2020. Resolution. HMDA is responsible for the loss of 2 months of work time and which forms part of the total delay, and hence is liable under the liquidated damages clause to the contractor, and then has to bear the total cost of the parking and repair charges of vehicles for the period of 2 months, 24/2020 to 20th June 2020, calculated at 100% of the actual subject to the total limit of liquidated damages mentioned in the contract. Dispute number 4. Government of India allowed limited resumption of the work on 24/2020 as HMDA was not quick on the take to permit or instruct the contractor to resume the work. The contractor on 2/5/2020 wrote to HMDA to allow it to use its assets for another third-party work till HMDA makes up its mind. HMDA refused permission and was cause for loss of business and profit till 26/2020, that is 1 month and 18 days. Resolution. The parties hotly contested this claim and finally agreed that HMDA will make good 10% of the expected profit for the opportunity loss for the value of work that the contractor could have undertaken for the third party from 2/5/20 to 26/2020 as a loss of expected profits. Dispute number 5. The contractor claimed 1 crore 24 lakhs in addition to the expenses and losses mentioned above on liquidated damages. Resolution. In view of the resolution of the dispute 2 to 4, and the generous disposition of HMDA, the contractor has agreed to withdraw the said claim on a without prejudice basis. It was agreed that this claim and its withdrawal would not go to or be used to discredit the contractor in any way or affect his other rights and responsibilities under any other act, rules or contract. In witness whereof, this agreement has been signed 8th day between Vega Construction, HMDA, and in view of witness of the by the conciliator.